2015. Would you please call the roll?
Chairperson Batcher,
Here?
Member Shavaro,
Here.
Member Hill,
Here.
Great, we're all here. Would you please join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I keep pushing my chair to you, I'm sorry. Thank you very much. Item number 1 on the agenda is the approval of the minutes of the March 21st, 2019 board meeting. Are there any additions or corrections to the minutes?
I'll move to accept as submitted.
Second.
Okay, it's been moved and seconded to approve the minutes of the March 21st, 2019 board meeting. All in favor? Aye. Thank you. The next item, number 2, is the public comment item. This is the item that gives the opportunity of the public to comment on items that are not on the agenda today. If you would like to make a comment, please come forward, state your name for the record. Okay, thank you. I see none. Number 3, item on our agenda today is the executive officer's statement. Julie, would you like to give your report?
Yes, thank you, and good morning to you, Madam Chair and members. April is a very busy month for us as we are observing both Sexual Assault Awareness Month and National Crime Victims' Rights Week. On April 4th, Governor Newsom proclaimed the week of April 7th to 14th as California's National Crime Victims' Rights Week to show support for victims and survivors and to recognize their rights to be heard and treated with fairness, dignity, and respect. We also, early this month, deployed a soft launch of our CalVCB Online, which I've demonstrated to you before, which now allows applicants and those assisting them to apply for compensation from a computer, a tablet, smartphone. Users can also check the status of their applications online and communicate with customer service in the same manner. And since that soft launch on April 4th, 270 applicant user accounts have been created and 104 applications have been completed and successfully imported into our processing system. So far it's going very, very well.
That is exciting. Wow.
We're very proud of the hard work of both our program staff and our IT team and all the support from everyone in the
Talk to you all and
organization.
take you over to the DMV with me.
So this soft launch is giving us the opportunity to fine-tune our operations and to refine as needed the online system prior to the official deployment. And then we're working on a broad outreach campaign that will create awareness about this online system among the general public, crime victims, advocates, law enforcement, government agencies, and service providers. And we're expecting the public launch to occur sometime this summer. So it's going well. We'll do a lot of outreach and show people just how easy it is, and then we'll move on. We have other components to the online system that we'll be adding in the coming months, but this is the most significant. Again, my sincere thanks to all involved. It was a very, very smooth, and this project was, I won't call it a project, this effort was done with in-house resources.
No, it's just super. I'm proud of you all throughout the state government that we have to move into the digital world. And this is a great success of that. We may showcase you in other departments that we have challenges in.
All right, going on, I won't keep you too long on this, but during National Crime Victims' Rights Week, we attended many important events. I'll just summarize a few of those. Last week, we partnered with Crime Victims for Safety and Justice on 2 events. Christy, our Deputy Executive Officer, took part in a panel discussion with Cal OES, OJP, and various other state agencies to discuss crime victim assistance. And then, kind of a first time for us, we hosted a claims clinic, an information table at the Capitol, which was part of the setting for this conference. And we were able to utilize our online access application in a tent on the lawn of the Capitol in the field for the first time. And we met with victims and helped them file their applications electronically using iPads and tablets. The survivors that we helped during that afternoon were very pleased with the online system and felt that it was actually very easy to use. And they were also grateful to have the on-site assistance of our staff as they filled out their applications. So that was very rewarding again for all of us involved in that. On April 10th, we attended CDCR's Moment of Silence and commemoration ceremony. Our very own Chief Counsel, Lorinda, spoke at the Victims' Rights Symposium at McGeorge School of Law regarding our funding and the importance of restitution. And just yesterday, we hosted a Facebook Live event with Empower YOLO, where a guest from Empower YOLO came and spoke live on Facebook, talking about the need to raise awareness about sexual assault and sharing information with victims on where they can get assistance. And then next week, Robin Fumbleby and our ombudsperson, Anita, will be attending the Mass Casualty Crime Response workshops in San Francisco with our county partners. And finally, that is not enough for 1 month. We also have Denim Day. We have we have our annual Denim Drive, which is ongoing. You'll see those containers in the foyer. And then on April 24th, we will have the official observance of Denim Day with our annual picture in the lobby. So we've been keeping busy, doing some excellent work, and thank you for your support of all the things that we have undertaken and will continue to do.
It's terrific. It has been a busy month, but all well done. Thank you.
Thank you.
Thank you to staff as well. Does anyone have any questions or comments of Julie's report? Okay. We'll move on to item number 4, which is the contract report.
Yes, I
Julie, want
have
to give us that?
yes, Madam Chair, I have 3 items for you this morning. The first is our we call our CRC county contracts. These are counties in 24 individual contracts with DA offices. And they work with the criminal justice system to ensure that restitution fines and orders are administered and that we receive orders that reimburse us for the services that we have provided to victims where there is prosecution and conviction and the opportunity to collect that sum back. So this is 25 contracts. You have a sheet behind the summary report that shows you the contracts by county and the amount. The total amount for these 25 contracts is $9,220,395. This is funded through the restitution fund, and the term of these contracts is July 1/19 to June 30th, 2022. So I'd ask for your approval of that item.
Okay.
Second.
It's been moved and seconded to approve the contract report as stated. All in favor?
Aye.
Thanks,
Thank
Julie.
you. Next, we have an IT-related item, purchase order, and the vendor's Global Blue DVBE in the amount of $150,886.35 for upgrades to our hardware, basically our core network switches. So this is an important item to keep us running as efficiently as we always have. So I would ask for your approval of that.
Second. It's been moved and seconded to approve the contract for the hardware upgrade. All in favor?
Aye.
Thank you.
Thank you.
And finally, we have an amendment to our ongoing contract or interagency agreement with Cal HR for statewide training. We are big fans of Cal HR training and have used their services extensively, and it's now time to augment the contract so that we can continue to provide those training opportunities for our staff. So this augments the contract in the amount of $55,000.
Great. I'm all for that.
Okay.
Help out another sister agency.
Absolutely.
Okay. We have to vote on this as
You can
well.
go ahead
since
and
it's
just- yeah.
amendment.
No, it's
okay.
just for formality, go ahead.
Okay, why don't we, okay.
Second.
It's been moved to approve and it has been moved and seconded to approve the Cal HR amendment amendment to the CalHR contract, All in favor?
Aye.
Aye. Okey doke.
That's it. Thank you very much.
Appreciate that. Item 5 of the agenda today is our legislative update. I think, is Lorinda going to be doing that? Yes. Lorinda?
We have quite a few changes to the legislative update since the binders were submitted to you. The first one is the introduction of AB 1830. That is our second erroneous conviction claims bill, and that bill would appropriate $2,317,140 from the general fund to pay the erroneous conviction claims approved by CalVCB for Marco Contreras, Emmanuel Castillo Lopez, Deshaun Reed, and Horace Roberts. The second change is to AB 351, which is on page 1 of the legislative update in your binders. That bill has been completely gut and amended. The bill would now authorize a juvenile defendant or ward to be charged a fee for processing an installment account and a fee for processing a credit card transaction, and would generally authorize a reduction of the fines imposed if the defendant or ward established an auto payment linked to a valid bank account. The next change is to AB 702, which is the top of page 2 of your legislative update. That bill has now passed out of the Assembly Public Safety Committee and has been referred to the Assembly Appropriations Committee. AB 927, which is next up on the list, was placed on the suspense file in the Assembly Appropriations Committee. AB 1449 passed out of the Assembly Public Safety Committee, but the author accepted committee amendments that are not in print just yet, and it's now been referred to the Assembly Appropriations Committee. Two more updates. The next one is on AB 1764, which is also on page 2. That bill is scheduled to be heard now in the Assembly Public Safety Committee on April 23rd, so next week. And then finally, SB 375, which is on page 3 of your updates. That has now passed out of the Senate Public Safety Committee and is scheduled to be heard in the Senate Appropriations Committee on April 22nd.
Busy time at the legislature.
Very much so.
Okay, good report. Any questions on the legislative report? Okay. We'll now move on to item number 6 of our agenda. It is Penal Code Section 4900 claim of Daniel Clark. That will be presented by CalVCB Senior Attorney Lori Simpson. And Laura's coming to the table. And we also have the Deputy Attorney General. Or could you restate your name, please, for the record?
Good morning, Madam Chair and board members. My name is Laura Simpson and I'm LVCB. Daniel Clark filed his application for compensation under Penal Code Section 4900 based upon 5 convictions involving TG, who is the mother of his children. He seeks compensation in the amount of $432,600 for having served over 3,000 days in prison for forcible rape, attempted forcible oral copulation, residential burglary, criminal threats, and false imprisonment, all of which allegedly occurred on the night of May 21st through 22nd of 2005. Clark does not seek any compensation for the days he served in prison for inflicting corporal injury on TG 2 days earlier on May 19th of 2005. 1 month before these events in April of 2005, TG obtained a permanent restraining order against Clark based upon an uncharged incident of domestic violence. 2 days later, Clark filed for custody of their young son. On May 19th of 2005, according to TG, Clark unexpectedly arrived at her home, held a knife against her throat, and hit her pregnant stomach 3 times in an effort to dissuade TG from speaking to a mediator about child custody that was scheduled for the next day. TG reported the incident to police and the officer documented a minor cut on TG's neck. Clark, however, claimed that he was at his own apartment with friends when this incident occurred. On the night of May 21st, 2005, according to TG, Clark broke into her home while she was sleeping and sexually assaulted her for hours. TG was 7 months pregnant at the time. Clark also threatened TG with a knife and held a blade against her neck, chest, and inner thighs, causing it to cut her when she struggled. TG eventually called 911 while Clark was in the bathroom. The responding officers noted TG's frightened demeanor and seemingly fresh scratches. No blood was detected on TG's sheets, but a blood stain was located on the knife. A forensic examiner photographed abrasions and lacerations on multiple areas of TG's body. But according to Clark, TG had invited him over that evening to bring diapers, although he later claimed it was to let TG sleep while he tended to their young son. He insisted their sexual activity was entirely consensual and denied causing any of TG's injuries. He claimed that TG had self-inflicted her wounds as part of an elaborate setup for the custody hearing that was scheduled for 2 days later. Following a jury trial at which both TG and Clark testified, Clark was convicted of all charges and sentenced to 32 years to life in prison. The California Court of Appeal reversed due to counsel's failure to present two medical experts' opinion that TG's cuts were likely self-inflicted due to their superficial nature, parallel patterns, and varying ages. Clark was retried a second time and convicted again. The trial court denied Clark's motion for a new trial based upon a new report from one of the prosecution's experts who opined that TG's cuts were likely self-inflicted. The California Court of Appeal reversed a second time, finding that the trial court's denial of the motion amounted to an abuse of discretion. In lieu of a third trial, Clark pleaded no contest to inflicting corporal injury on TG during the May 19th incident, and the prosecution dismissed the remaining charges related to the May 21st incident. In the proposed decision, the hearing officer recommends denying Clark's application because he has not satisfied his burden of proof. The hearing officer found Clark lacked credibility given his still valid conviction for domestic violence against TG, his inconsistent statements, and the prior uncharged act of domestic violence that resulted in a permanent restraining order. By comparison, the hearing officer found TG's version of events to be credible, even assuming her wounds were not inflicted in the manner she claimed. Overall, the hearing officer concluded that compensation should be denied because the evidence failed to prove that Clark was more likely innocent than guilty of rape, attempted oral copulation, burglary, criminal threats, and false imprisonment. In today's hearing, Mr. Clark is represented by his attorney, Faye Arfa, who is appearing by telephone, and the Attorney General's office is represented by Deputy Attorney General Craig Myers.
Okay, would Mr. Clark's attorney like to speak at this time? Present the statement?
Ms. Arpa?
Hello?
Hi, Ms. Arfa?
Yeah, I got disconnected. I've been watching on TV here.
I apologize about that, ma'am, but you are, it's your item if you would like to speak.
I would. Yes.
Go ahead. You can present your statement.
Okay. Okay. Can everyone hear me?
Yes, we can hear you fine. Thank you.
Okay, great. I want to emphasize to the court that the facts that the prosecution or the respondent is bringing up are based, those facts were discredited by the Court of Appeal. They keep raising these facts, but after two court opinions, they are not valid anymore. What the prosecution did in this case was fail to recognize the exculpatory evidence and the value of the expert opinion. It wasn't a question of credibility. It was a question of whether or not the evidence supported what she was saying. And what we had, which is extremely unusual, we had both defense and prosecution expert witnesses agree that these wounds were not inflicted by Mr. Clark on the night of the incident. And that was by both experts. And not only that, the prosecution hid the second expert's report the favorable report from their own expert saying that the wounds were self-inflicted. They were inconsistent with her testimony. And so I don't understand why the prosecution, why the respondent, why the government here keeps bringing up discredited facts. She has no credibility because the forensic evidence by both sides, by both the defense and the prosecution, show that the wounds were not inflicted on that day. And what happened was I actually filed a motion to dismiss based on prosecutorial misconduct because, in my opinion, they hid the evidence to thwart an acquittal. I mean, they were bent on getting a conviction for Mr. Clark without really looking at the evidence. The evidence showed that that he didn't inflict those wounds on that night, and it was, no matter how you look at it, she was the one who inflicted the wounds to herself, either that night or another night. I don't know. I think this evidence shows how important forensic evidence can be. It shows that, number one, he did not inflict the wounds. Number two, that she self-inflicted them. I understand what the jury found. I understand what she said, and I understand what he said, but he's been released. We entered into a compromise settlement where he agreed to take what was considered a serious felony, not a strike. He pled to domestic violence. We didn't want to spend another few years litigating this case and going through another third trial. But it seems, in all fairness, Mr. Clark spent over 3,000 days in custody for a case for something he didn't commit. And if the prosecution would have at least fairly looked at all the evidence, they would have known that. But they wanted to get another conviction. In the Court of Appeal opinion, I raised all sorts of other things about the prosecutorial misconduct, how they mishandled our experts. And it's very rare to get a conviction returned twice. So I think, in all fairness to Mr. Clark, he's been, he was let out. He was not on parole, but he deserves to get his life back together. And I believe that that's what the Victims' Compensation Fund money is all about. He was unfairly convicted, and we would ask the court to respectfully grant him some compensation for the wrongful convictions that he suffered. Thank you.
Okay, thank you. Would the Attorney General like to make a statement, please?
Yes, good morning, board members. Craig Myers with the Attorney General's Office for responded. The hearing officer got this right in her facts, in her statement of facts, and it's very important for the board members to acknowledge and realize that the two Court of Appeal decisions never found innocence. There's never been a factual finding of innocence in this case. The first case was overruled for ineffective assistance of counsel for Mr. Clark's attorney for not bringing medical experts to testify about the possibility of these wounds being self-inflicted. Mr. Clark did testify at trial that they were self-inflicted, that he felt they were self-inflicted, and he did not do them. They went back, they had another trial, and petitioner brought two experts who testified that, in their opinion, the wounds inflicted by TG, the victim, it's possible and probable that they could have been self-inflicted. They never testified, nor could they possibly testify, that they were self-inflicted. TG has never wavered in her testimony. There's no declaration on file that is anything different than when she testified the two trials, that it was a claimant who inflicted these injuries. The second trial was overruled in the Court of Appeal based on abuse of discretion for the trial court not granting the new trial motion. After conviction and before sentencing, it was revealed that the coroner, who was a consultant in this case, had written a report that stated that it's a possibility that they could have been self-inflicted. But none of the experts testified that it was self-inflicted. In fact, his own expert testified, this is Dr. Bronston, they gave a scenario that if a woman was being held at knife point and being raped and she was held perfectly still because she was afraid, as TG testified, could the wounds be inflicted in this manner? And he said, that's consistent. That's in my exhibit 26, page 1860. They also testified that there's no specific way to determine exactly a wound's age, and medicine could affect the wound's healing. The two experts that testified at the second trial for claimant were also inconsistent with claimant's own testimony. The scenario is that everybody agrees on whether it's disagreeing whether it was consensual or whether it was a crime, but they did engage in sex for like 3.5 hours, multiple times, and claimant testified at both trials he never saw any injuries on her prior. And then his expert is saying these injuries are a week or 3 days old. So it goes against his own testimony. This case basically comes down to credibility. And two juries heard claimant testify, they heard the victim testify, and they agreed with the victim. They agreed with the victim during the first trial, and they agreed with the victim in the second trial after two experts testified that in their opinion, these wounds could be self-inflicted. Going to credibility also is claimant's history of violence, criminal history, and Evidence Code 1109 specifically allows the court and this board to consider prior instances of domestic violence as propensity evidence to do future and current incidents of domestic violence. Claimant testified and pled guilty to beating up his 7-month pregnant wife 2 days before and holding a knife to her throat. There's many instances where he went over and he broke in, he beat her up, he held knives to her, he ripped a phone out, he threw the phone through the door of the house, and he lied about that during the first trial, said he didn't do that, and they testified the second trial that he actually did do that. So it's a credibility contest. We have no factual findings of innocence. The evidence was clearly presented in 2 trials. The hearing officer went through all that evidence, and I'm satisfied, and I hope this board is satisfied, that claimant cannot prove his innocence in this case. Thank you.
Thank you, sir. Okay, do we have any questions or comments to make?
I'll move staff recommendation.
I'll second it. It's been moved and seconded to accept staff recommendation on item number 6, Penal Code Section 4900 claim of Daniel Clark. All in favor?
Aye.
Aye. Thank you very much.
Thank you.
Thank you, counsel, on the phone as well.
Thank you.
Okay, we are now turning to item number 7. It's Penal Code Section 4900 claim of Timothy Atkins that will be presented by our chief counsel. Lorinda?
Good morning, Madam Chair and board members. Timothy Atkins seeks
Hold on a
compensation.
second, Lorinda. Let's let counsel get seated and Mr. Atkins. Sorry, I rushed you a bit. Okay, Lorinda?
Timothy Atkins seeks compensation for his wrongful conviction and incarceration pursuant to Penal Code Section 4900. He received a finding of factual innocence in August of 2014, which is binding on the board. In February of 2019, when this matter was last before the board, Mr. Atkins' counsel disputed the amount of compensation that Mr. Atkins is entitled to, rejecting the hearing officer's determination that the pre-2016 statutes applied. Following briefing and additional research by the parties, the hearing officer now recommends that the board recommend payment in the amount of $1,129,660, representing $140 per day for each of the 8,069 days that Mr. Atkins spent wrongfully incarcerated. This amount is calculated based on the post-2016 statutes. Appearing for Mr. Atkins is Alexander Simpson, Associate Director of the California Innocence Project. Supervising Deputy Attorney General Kenneth Sokoler is here on behalf of the Attorney General, and Mr. Atkins is also present today.
Good morning. Would you like to introduce yourself, Mr. Simpson?
Good morning. Yes, thank you. Yes. Thank you. My name is Alex Simpson. I'm the Associate Director of the California Innocence Project, and I represent Mr. Atkins.
Would you like to make a statement at this time?
Very briefly, and obviously my request to this board is to adopt the proposed decision for all the reasons described. I'd just like to, ahead of time, talk about some of the more kind of emotional impact of this and what this might mean in terms of redressing Mr. Atkins's wrongful incarceration. As this board is aware, Mr. Atkins went into prison when he was 17 years old. He got out when he was 40 years old. In that time, I don't think it's an exaggeration to say that the entire modern world was invented while he was sitting in prison for a crime that someone else committed. Ronald Reagan was the president when he went in. He sat through 3 other presidents being sworn in for while he was in custody. When he was convicted, the United States was still in a Cold War with Russia and the USSR. The Berlin Wall wouldn't fall for another 2 years after he was convicted. Osama bin Laden was a 30-year-old construction worker working with the CIA at the time and 14 years away from committing the September 11th attacks. He spent another 6 years in prison after September 11th, before he was released. Mr. Atkins was wrongfully convicted 2 years before the World Wide Web was invented. By the time he was released, Google and Facebook had been around for years. Cellular mobile telephones, when he was convicted, there were 800,000 cellular telephones total in the United States. And on the date he was released, the iPhone had just been released and 122 million cell phones were sold worldwide in that year alone. The scope of this is incomprehensible, and we cannot do anything to repair totally Mr. Atkins's years of wrongful incarceration. I am urging the board to accept the proposed decision because it's the right thing to do. And I thank you so much for being receptive to the discussions that we had in the last hearing and for hearing us out today as well. Thank you.
Thank you, Mr. Simpson. Thank you, Mr. Atkins. The Attorney General?
Kenneth Stekoler of the Attorney General's Office. I'll be happy to answer any questions that the board has.
Okay. Are there any questions or comments?
One question. When approved, this will go before the legislature this fall?
No, we're hoping
allocation?
we have a couple opportunities to bring the appropriation request before the legislature within the next 30 to 60 days, which is what we hoped for.
Thank you.
Okay. Rick, do you have any questions?
Second.
It's been moved and seconded to approve staff recommendation on item number 7, Penal Code Section 4900 claim of Timothy Atkins. All in favor?
Aye.
Aye. Thank you very much, Mr. Atkins.
Thank you.
Okay, we will now move into the Victim Compensation Program portion of our agenda. The board will convene in a closed session pursuant to Government Code Section 11126C3 to discuss numbers 1 through 30 of the Victims Compensation Program. reconvening into open session pursuant to Government Code Section 11126C. Item number 13 has been removed from the agenda today. Do I have a motion for numbers 1 through 30 of the Victims' Compensation Program with the exception of item number 13?
Second.
It's been moved and seconded to approve the staff recommendation on numbers 1 through 30 of the Victims' Compensation Program with the exception of number 13. All in favor? Aye. Thank you all. Thank you, staff, for all of your hard work in preparing us today. Is there any other business that needs to come before the board at this time? Okay, seeing none, the next meeting is scheduled to occur on May 16th. So thank you all very much, and thank you for such a busy month, and congratulations on all the hard work.